All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Thank you. Welcome back, everyone. Now we've reserved 2.5 hours so we can do that dash to the end. Professor Robinson will speak next, but as a matter of housekeeping, as we indicated earlier, anything anyone feels they need to say that they didn't get a chance to say, there's that 10-page indulgence given written matter that may be submitted afterwards. I say 2 weeks, let me point a date to it. 28th of September 2018 should be the deadline, will be the deadline. Thank you. Mr. Robinson, your turn.
Thank you, Mr. President. Thank you, Your Honors. I will continue my practice of short interventions. I was given generously 25 minutes. I expect to take 9. By hitting only the highlights, I hope I can make this really worth your while. I have 5 specific suggestions about drafting the judgment and then 3 short, more general suggestions. The first is I would suggest that you emphasize the ordinary meaning of cooperate fully. Several parties here have emphasized the importance of text. I suggest we do with what they say. I've referenced this before, but the Oxford English Dictionary definition of fully is completely or entirely to the fullest extent. And as I explained in a previous session, I think that means either we interpret that literally, in which case it means Sudan must do anything the ICC asks, or contextually and more generously, we give Sudan the benefit of the limitations enjoyed and available to states parties. The second suggestion is I think it's important to emphasize, because it's not necessarily clear to the world at large, the cooperation obligations are not only in Part 9, but throughout the statute. Examples are already in my brief. Those examples are needed in order for effective cooperation. And if we restrict it to the obligations in Part 9, that is not cooperating fully. The third suggestion is that it's important to highlight that Article 27.2 contains a cooperation-related obligation. It removes an impediment to moving forward specific cases. To demonstrate that horizontal effect, I think, again, I would suggest that you highlight text and ordinary meaning, and in particular, the word national immunities, which suggests that they do contemplate application not just at the ICC. Other arguments showing the horizontal effect have already been given in these proceedings. But I have a new thought about the text itself. Some of the parties here that are insisting on ordinary language are also insisting that Article 27.2 says in the courtroom. But Article 27.2 does not say in the courtroom. Article 27.2 says shall not bar the exercise of jurisdiction by the court. Now, I agree with the African Union. Of course, arrest by state officials is attributable to the state. That's clearly correct. But the issue here is not attribution. The question is, does it fall within the terms of Article 27.2? Here, I think the court might find helpful the idea of dédoublement fonctionnel, the dual roles. Sometimes state agents are doing things, and that's attributable both to their state, but they are also acting on behalf of an international organization. And I think that's what's happening here. Of course, states have immunities before foreign national systems, but the question is the Article 27 obligation, and does it displace that? So the interpretive question is surrender part of the exercise of jurisdiction by the court? And I think it is a part, it's an indispensable part of the exercise of jurisdiction by the court. Furthermore, I think it's almost universally agreed, except as of today by Roger O'Keefe, that between states parties, Article 27 informs the interpretation of Article 98. And what I suggest to you is it works the same for all those obliged to cooperate fully. It's a cooperation obligation. The African Union asks, well, if Article 27 removes immunities, then why is Article 98 in the statute? And the answer is, it preserves immunities of those states that are not subject to the obligations. Fourth suggestion, I think the appeals chamber should expressly respond to a powerful and commonly made criticism that this technique is, quote, turning Sudan into a party. We've discussed this already. It's important to emphasize. This obligation is imposed by the UN Security Council pursuant to the UN Charter, but by reference to the Rome Statute. And it's important to point out two limits. The Council's only imposed the cooperation obligations, not the governance obligations. And number two, it's only in relation to one situation. And the Council, it's probably also worth noting the Council did this in response to a threat to international peace and security, which was the killing of 300,000 human beings. I have a new idea to offer. I realized last night that part of the impasse in this room, part of the ways we're not understanding each other, Sean Murphy made a great point about the extent of treaty obligations being imposed on Sudan, and that thought struck me. And I realized the underlying objection of Jordan, AU, some Amici, on their view, the ICC is just some statute, some treaty. It's just some treaty getting imposed on a non-party. Whereas in my mind, I think on this side of the room, we see the ICC as a standing facility meant to be available to the UN and the Council as an alternative to continuous new ad hoc tribunals. And I think it might be useful to point that out in a judgment, because that might make the imposition of these obligations seem less strange. It would be useful to—
There may be somebody on that side of the room who doesn't share that view.
There is, yes, there is, yes. It might be useful to cite the report of the Ad Hoc Committee 1995 at paragraph 120. Interestingly, the International Law Commission already debated the issue of, does the ICC need to be a subsidiary organ of the UN in order to do this? The ILC concluded it's sufficient to create the ICC by treaty and bring it into a close relationship with the UN through a relationship agreement. And you can see that in the ILC report on the draft statute, 1994, in the commentary to Article 2. And that's exactly what was done. The ICC was created. It contains Article 2. A UN relationship agreement was adopted by the General Assembly. If it's somehow problematic to impose the ICC because it's a treaty, if it's somehow inferior to tribunals, then that defeats that particular enterprise. We have to go back to creating ad hoc tribunals. So I think it is worth noting that it's meant to be a standing facility linked to the UN, obviating the need for tribunals. My fifth suggestion is that the appeals chamber should respond to the argument that is confidently expressed that the Council has to be explicit in order to remove immunity. The argument is prima facie very plausible, but it's important to point out that we already have Security Council practice directly on this point. The Council has already removed immunities. The technique it used was ordering states to cooperate fully with an instrument that removed immunity. The ICC statute is actually clearer than the precedents because they also added Article 27 too. Jordan and the AU suggest, well, the Rome Statute is different because it includes Article 98, which confuses matters. But Article 98 only matters if someone has immunities opposable to the ICC, and Sudan's immunities were removed. So I close now with my three quick general suggestions. The first one is, as we all know here, this is a very controversial and divisive issue. If the chamber is able to find some middle ground, I think that would be commendable. Mr. President, you talked about injecting common sense into law. If the tribunal were minded to suggest that there could be scope for consultations on essential contacts, I think that could be an important safety valve here. I think if there were such a suggestion, it would be important to require that states consult the court in a timely manner so that there's time for the court to respond yes or no. Second of my general suggestions, as for referring Jordan, my group of scholars suggests that there are errors of fact and law on the two main arguments of the chamber to refer Jordan, so there is a ground for the appeals chamber to reconsider it. We think Jordan was not being defiant. Jordan was just stating what it perceived as obstacles. The pretrial chamber said the law had been unequivocally settled, but in fact, error of fact, the South Africa decision was not yet available. The theory that Jordan objected to has been significantly refined. We know that this matter is intensely controversial throughout the community in the best of faith. Moreover, the referral test asks what is best for cooperation, and I hope that we will ask that question with a big picture vision of what's best for cooperation. I'll stop there. I'll just do two suggestions, actually. So I thank the bench for granting leave to my group, and I thank you very much for your generosity to the amicus curiae in this matter. Thank you.
Thank you very much, Mr. Robinson. And that was much well within your time limit. Now we will go to the round-up remarks of the prosecutor.
Good afternoon again, Your Honours. In our final remarks, the prosecution will briefly return to highlight our position and address a few points that we believe may still benefit from clarification. I plan to be about 15 minutes. I'll give a final overview of our position on all three grounds and address one specific issue on ground 2 relating to the Security Council's referral and Resolution 1593. Mr. Cross will then address you for about 15 minutes on ground 1 on Articles 27 and 98. Mr. Raston will briefly address a few points from the customary international law discussion, and Ms. Narayan will do the same on a few issues relating to Jordan's referral. Your Honours, in the prosecution's view, the pre-trial chamber was correct to find that Jordan failed to comply with the court's request to arrest and surrender Mr. Bashir, and we ask you to uphold that decision. In our view, the majority's reasoning, based as it was on its interpretation of the Rome Statute, Articles 27 and 98, and the effect of the Security Council's referral by Resolution 1593 was the most straightforward and legally convincing articulation for reaching that decision. In our written submissions and our oral submissions throughout the course of this week, and in answering your questions, we have entertained and we've recognised that there are other legal theories that would be equally valid and would lead to the same conclusion reached by the pre-trial chamber. But when all is said and done, we maintain our position that the appeals chamber should follow the course taken by the majority, not only as a matter of judicial economy, but also as a matter of best appellate practice, as I answered Judge Hofmansky's question the other day. Specifically, on ground 1, the court correctly analysed Article 27 and 98, their interrelationship, and their effect on head of state immunity at the court. Importantly, the second paragraph of Article 27, by not allowing immunities based on official capacity to bar the court from exercising jurisdiction, does have what we've referred to in these proceedings and in the judgment as both vertical and horizontal effects for states bound by the obligations in the Rome Statute. As a result, any personal immunity under customary or conventional law that a head of state like Mr. al-Bashir may otherwise arguably enjoy under international law cannot procedurally bar the court's exercise of jurisdiction, including enforcement of its arrest orders. For state parties to the ICC, the reach of Article 27.2 is clear. When they ratify the Rome Statute and they consent to its terms, they agree to the inapplicability of immunities, including that of a head of state, for their own state officials. Neither the suspect or his or her state of nationality can raise head of state immunity to bar the court's proceedings, including its request to arrest that person. The horizontal effect of Article 27.2 for state parties is equally clear. If a state party receives a request from the court to arrest and surrender a head of state of another state party, it must comply. It cannot argue that head of state immunity held by the non-requested state party prevents it from enforcing the court's order. Why? What's the rationale? Because the requested state party must proceed on the basis that the state party whose official is sought is likewise vertically bound by its obligations in the statute, especially Article 27.2, and is unable to raise its official's immunity before the court. This means the requested state party is obliged to arrest and surrender that official and cannot raise Article 98.1 as a bar. In that circumstance, it becomes irrelevant or inapplicable, since there is no inconsistent obligation owed to another state under international law. In what circumstances, then, does this vertical and horizontal effect for state parties apply to non-state parties? And this is perhaps the real crux of the appeal and the subject of ground 2. Most relevantly for the present case, it's when a non-state party is bound by the obligations in the statute by virtue of a Security Council referral of a situation in its territory. And this is the position that Sudan was in by virtue of Resolution 1593. The Council's referral of the situation of Darfur to the ICC, using its Chapter 7 powers, obliging Sudan to fully cooperate, meant that the Rome Statute framework applied to the Darfur situation and did indeed place Sudan in a position analogous to a state party. Sudan was thereby obliged to respect the cooperation provisions of the statute, and those provisions on cooperation include Article 27.2. So it's really by the combined effect of the Rome Statute, Resolution 1593, and the UN Charter that Sudan was obliged to arrest and surrender its president, notwithstanding any immunity to which he may otherwise have been entitled. But because Sudan is bound to comply with the court's request to arrest and surrender their head of state, the same logic applies as in the state party situation. That means a state party, here Jordan, requested to arrest and surrender that head of state is obliged to comply with the court's arrest warrant and cannot rely on Article 98. Again, why? Because it's not being asked to act inconsistently with its obligations under international law in respect of the state immunity of Sudan. I want to emphasize at this point how we see the interrelationship between paragraphs 1 and 2 of the Security Council resolution, Resolution 1593. In our view, the majority was correct that the referral of the situation was in itself sufficient. This is paragraph 1, was in itself sufficient to bind Sudan to the obligations in the statute. It made it akin to a state party. It invoked the cooperation obligations under Part 9 and other relevant cooperation provisions, including Article 27.2. And because Sudan was vertically bound to comply, this had consequential effects for how Jordan was to approach the request. That was the holding of the majority, and we agree with it. But as I also stressed, if we then look at the resolution itself, especially paragraph 2, requiring Sudan to fully cooperate, we can see the Security Council's intention that immunities would be disapplied. And this comes from reading paragraph 2 in context and in light of the resolution's drafting background and object and purpose. On the question raised the other day, well, why have paragraph 2 in the resolution if referral already had the necessary effect? The answer is simple. Paragraph 2 is confirmatory of that effect for Sudan. Indeed, we would find it odd if in a resolution referring a situation in that country that there was not a clause specifically directed at it. So for us, these interpretations of paragraph 1 and 2 are what we would call mutually supportive and reaffirming. They operate together. But equally, in our view, you could rely on either one on its own and still reach that same conclusion. Finally, just briefly, on ground 3, in our view, the pretrial chamber did correctly exercise its discretion. It made no error in referring Jordan to the ASP and the Security Council. The reasoning may have been concise, at least in that portion of the decision, but the chamber considered the relevant factors, namely Jordan's clear position and choice not to comply before the visit, made at a time when Jordan was on notice of the court's position that state parties were obliged to arrest and surrender Mr. al-Bashir to the court, and considering the manner in which it approached the court the day before his visit. Your Honour, before handing the floor to Mr. Cross, the prosecution would like to acknowledge the obvious complexity and the novelty of the issues in this appeal, and we recognise that this is the first time that the Appeals Chamber is addressing these issues on Article 27, Article 98, and the immunity of heads of state. So in many ways, it's very much a matter of first impression for this court. And we also recognise that the appeal concerns issues that overlap with more general principles on public international law, and that are both important and sensitive for all states, state parties and non-state parties alike. And the prosecution appreciates the open and rigorous manner in which Jordan, the African Union, the League of Arab States, and all the invited amici have approached the topic. And even though we have quite markedly different views on many of the topics discussed, the legal debate for us has been a highly constructive one. In sum, Your Honours, the issues in this appeal go to the core of the court's ability to arrest and surrender persons to the court, and hence its ability to effectively exercise its jurisdiction. But at the end of the day, to ensure that this court can do what it was designed to do, end impunity for crimes which are of concern to all of humanity, its warrants must be enforced. The current situation, where the court is paralysed from functioning in this situation because some of its own state parties refuse to enforce its request, should not continue. A decision upholding the appeal, a decision upholding the decision on appeal can go a long way to stop that impasse. And I'll now hand the floor to Mr. Cross. Thank you.
Good morning, Your Honours. Your Honours are, I would imagine by now, well aware of the primary arguments which show, in our view and the view of others, that Article 27.2 prevents states, parties, and other relevant states from raising official capacity to bar arresting and surrendering their own officials, the so-called vertical effect of Article 27.2. And, as we have said, in our view, these arguments are based on the Vienna Convention criteria of the ordinary meaning of the terms, the context, and the object and purpose. But rather than repeating those arguments to you again, I would like to focus in these submissions on two other important considerations which have so far received less attention. I will also briefly address one matter raised yesterday, and so I have 3 points for your honours. My first point concerns supplementary means of interpretation under Article 32 of the Vienna Convention. Now, it's clear that our vigorous and informative discussions in this courtroom, that the different counsel in the room speak not only with different legal views, but also come from different legal backgrounds. Distinguished members of the ILC are, of course, extremely well represented, as are distinguished academics. But we are also fortunate to hear from actual delegates to the Rome Statute negotiations. Now, they have been extremely modest in their interventions, and they have sought to ensure that their remarks remained objective and verifiable at all times. And in particular, amongst these persons, if I recall correctly, I refer to Ms. Latanzi, Mr. Kress, Mr. Robinson, and indeed my colleague, Ms. Brady. But their modesty does not excuse us from the duty of asking that important question, which is so often a vital aspect of treaty interpretation. What evidence do we have of what the drafters of the statute actually intended? After all, the points which arise in this case are not only important, but they were also eminently foreseeable. And this question is perhaps most apposite for Article 98.1, which all the parties and participants have sought to rely upon in different ways. Indeed, this morning, both Counsel for the African Union and Mr. O'Keefe have stressed the relevance of this provision. To answer this question, and with apologies for any embarrassment it may cause to Mr. Kress, I will simply read out a brief passage from his observations written together with Judge Prost in her capacity before she was elected as a judge of this court, coming from the third edition of Otto Trifterer's commentary at page 2119. And this reference is also cited in footnote 30 of our filing 377. Mr. Kress and Judge Prost begin, and I quote, "The subject matter of Article 98 did not hold a prominent place in the negotiations on Part 9 for a long time." Then, in the next paragraph, they add that indeed, and quote again, "the issue of conflicting immunities was rather reluctantly addressed by some delegations, which were of the view that developments in general international law had substantively reduced, if not eliminated, immunities with respect to crimes under international law as listed in Article 5. Mr. Kress and Judge Prost then conclude, and this is my final quotation, "The solution found in Article 98 is a rather complex one. It was recognized to be both impossible in the time available and undesirable to set up a list of those international obligations regarding immunities," and here I skip a small passage and then continue, "that would indeed conflict with the obligation to surrender under Article 89, paragraph 1. It followed that the determination as to whether a real conflict existed had to be taken on a case-by-case basis. With a view to the relevant future practice, the drafters once more wished to emphasize the competence of the court to authoritatively rule on the matter." And that ends the quotation. Now, Your Honours, we have heard nothing from anyone in this appeal to contradict this account of the drafting history of Article 98.1. And we say that it follows, Your Honours, that the drafter's intention, therefore, was for precisely the kind of process that we have today. Specifically, the drafters provided a broad framework for this court's analysis, including Article 27 and all of Part 9, but they deliberately refrained, in Article 98, from laying down particular rules concerning any immunities which might be opposable to requests for arrest and surrender. Instead, as Mr. Kress has also emphasised in his submissions, they created a procedure in which Your Honours could decide. In particular, and crucially, Article 98.1 cannot be read as any reflection of the view that the court can never proceed with a request for arrest and surrender of an official of a third state, whether that third state is a state party or not a state party, without waiver. If this had been the drafter's intention, then the middle part of the first clause of Article 98.1 is entirely unnecessary. It would simply say instead, and this is obviously hypothetical, the court may not proceed with a request for surrender or assistance with respect to the state or diplomatic immunity of a person or property of a third state without the waiver from that third state. But that is, of course, not what Article 98.1 says. Now, coming to my second point. One of the concerns raised by my learned friends, especially at the start of the week, was that they found the notion of the horizontal effect of Article 27.2 somehow confusing or perhaps alien to the statute. We disagree. There's nothing mystical about horizontal effect. It's just a way of trying to describe some of the additional consequences which might flow from an obligation owed by a state to the court. And it's not an idea that you would expect to find explicitly in the statute because it's essentially a matter of logic. But, that being said, the statute does contain a very significant clue, and that is in Article 86, as both Ms. Latanzi and Mr. Robinson have mentioned this morning. Now, the basic idea of Article 86 is simple, setting out the general obligation to cooperate, that's in the title, and requiring each state party to, quote, cooperate fully, unquote, with the court, in accordance with the statute. And since Article 86 is followed in Part 9 by detailed provisions which address states parties' specific obligations to cooperate, the legal effect of Article 86 must lie in its imposition of a particular standard of cooperation. Otherwise, it would be a mere preamble. Again, as Mr. Kress and Judge Prost have said, and that's reference C1 in filing 385, Article 86 must have a normative impact of its own. And if Your Honours were still in any doubt about the importance and relevance of Article 86, you might also take comfort from Resolution 1593 itself in paragraph 2, which again specifically places that same obligation of full cooperation on Sudan. And we say this cannot be a coincidence. Nor can cooperating fully just be a pretty sentiment. It means, rather, that states parties are not only bound by the specific obligations in the statute, such as in Articles 27 and 89, but also that states have accepted that they may not act inconsistently with those obligations that they have freely assumed. In this way, Article 86 may well have a common ancestry with other notions, such as the abuse of right doctrine and the like, which we discussed yesterday. You might even go so far as to call Article 86 an anti-loophole provision. In any event, it is of crucial importance. So what does it mean in practice? as your honours know, Sudan is obliged to arrest and surrender Mr. al-Bashir in accordance with the vertical effect of Article 27.2 and Article 89.1. And it cannot be doubted that it must also cooperate fully with the court, both under Article 86 and Resolution 1593 itself. So the question arises whether Sudan would be cooperating fully with the court, especially with regard to Article 27.2, displacing any claim of immunity on behalf of Mr. al-Bashir, if it sought to assert that same immunity against Jordan when Jordan acts on behalf of the ICC and at the request of the ICC to arrest and surrender Mr. al-Bashir. We say it would not be. If Sudan cannot rely on immunity directly before the court, it cannot rely on immunity indirectly before the court. To claim otherwise would be a mere formality, and would be to rely, I beg your pardon, on a mere formality, which is the necessity of the court executing requests for arrest and surrender through a state party. And it would do this in order to defeat the primary obligation which applies to Sudan. This simply cannot be right. It lacks the essential foundation of good faith which underpins Article 86 and permeates the entire cooperation regime, indeed, of Part 9. And it's this same logic, although perhaps expressed somewhat differently, which underpins the idea of horizontal effect of Article 27.2. And on this basis, therefore, we say the pre-trial chamber majority was right to find that Sudan could not assert immunity against Jordan for the purpose of the ICC arrest warrant, and that therefore Article 98.1 was no bar to requesting Jordan to arrest and surrender Mr. al-Bashir. And now, in my last 4 minutes, Your Honour, the third point. The question was raised yesterday whether Article 27.2 also applies to agreements falling within the scope of Article 98.2. Now, obviously in our view, this question does not arise on the facts of this case, but very briefly, we say that it would, and for similar reasons. Articles 98.1 and 98.2 differ, in our view, with respect to the types of agreements to which they apply. 98.1 applies to all kinds of obligations relating to state or diplomatic immunities. 98.2 applies to specific international agreements as defined by the terms of 98.2 itself. These may include status of forces agreements, status of mission agreements, and similar agreements if they fall within that definition. But Articles 98.1 and 98.2 are similar in the way that they work in practice. Both of them require the court to consider whether the requested state would be required to act inconsistently with its obligations, and both envisage the possibility that the third state or the sending state can disapply that conflict. Consequently, if that third state or sending state is itself subject to the obligations of the statute under Article 27, then again, the court, and I stress it is the court, may well decide that no inconsistency arises. Indeed, to reason otherwise, in the abstract, would lead to the view that states parties could simply contract out of Article 27.2 on an ad hoc basis. And we say that cannot be right. And at that point, Your Honours, I thank you very much for your attention, and I yield the floor to Mr. Vaston.
Thank you, Your Honours. I will not be very long. So, having heard a recap of our basic argument and our approach to this appeal, I just wanted to take no more than a few minutes to recall also our response to the arguments raised by Jordan, the AU and others, that the personal immunities of Mr. Bashir under customary international law remain unaffected by Security Council Resolution 1593, and that this being such a fundamental rule of international law, it cannot be displaced absent express wording in the resolution itself. Now, you've heard our submissions on why we think that is not the case and why, through the process of the combined operation of the different instruments, the Security Council Resolution, the UN Charter, the ICC Statute, the Relationship Agreement, we believe that is not the case. But I also wish to merely recall and also to invite the Chamber to examine the assumption behind the position that we understand Jordan has proposed. The position that the customary rule of international law forbidding the assertion of foreign criminal jurisdiction against the officials of another state is transferable to the ICC surrender process, to the extent necessary, obviously, for your judgment. We invite you to examine that assumption. Now, having listened to the various arguments, we remain convinced, and perhaps even more clearly today than when we started these hearings, that Jordan and the amici supporting its position on custom have really done nothing more than assert that this is so. We believe that they have drawn an analogy to the assertion of national criminal jurisdiction, or simply asserted that the execution of an ICC surrender process by national authorities is the exercise of domestic criminal jurisdiction. We suggest that no evidence has been presented to support this proposition or assumption, in line with the time-tested case law of the ICJ, and as we said, of other international courts and regional tribunals, national courts, etc., on the standard of proof and the burden of proof for identifying the existence of an alleged customary rule of international law or the formation of a new rule. We noted that an empirical analysis of actual state practice and opinio juris, evidenced by such classic criteria as statements of states, legislation, domestic court decisions, amongst others, actually demonstrates divergence on the question whether the domestic execution of an ICC surrender request falls within the scope of the existing rule of customary international law on personal immunities. Now, if the Chamber agrees with our analysis, then the precursor question of whether the government of Sudan can assert the personal immunity of Mr. Bashir against his surrender by another state to the ICC leads to the conclusion that it cannot. And as we stated earlier, the absence of a relevant rule of custom that might potentially or possibly be opposable to an ICC surrender request, we say, means that Jordan would not have owed any duty towards the Sudan as a matter of customary international law, were it to have surrendered him to the court. And moreover, absent relevant customary norms means that this chamber should direct its own analysis back to special international law in determining the relevant scope and effects of the different treaties that bear on this question in the manner my colleagues have just addressed. Now, Your Honours, this brings me, and I won't rehearse the submissions, but this brings back to some of the discussion that we've heard on state practice and opinio juris. And we've discussed at various points throughout these proceedings where the evidence of state practice and opinio juris may be found. And in this context, I wanted to offer just several observations on Mr. Newton's submissions regarding his data set. I'm sorry that he's not here today, but while we welcome Mr. Newton's helpful efforts to compile as many sources that may be available from public sources, there were several suggestions that this data set exhaustively or comprehensively captured relevant state practice in this regard, or that, even if incomplete, that it constituted the best record available and should, as such, form perhaps the basis of Your Honour's assessment of state practice and opinio juris. We only wish to make the obvious point, brought out by also Judge Borsa's question, that since this data set is based on public media sources, it cannot possibly take into account all relevant data, including practice concerning trips not considered or cancelled, or evidence that might exist in confidential diplomatic correspondence, which is the way that states normally interact on such matters. And in this context, we find it hard to understand the response to Judge Bosa's question on this point, where Mr. Newton stated that while he may have missed a few things, they would not be significant in number. If, as Mr. Newton admits, his data could be incomplete on this count, how could he quantify the size of what is missing? How can he know the scope of what is unknown? More generally, on whether the dataset of Mr. Bashir's record represents state practice, we also wanted to state the obvious, that Mr. Bashir, by selecting where he can travel safely through pre-contacts, cannot create his own supporting state practice. Nor should we rely solely on such trips as the sole evidence of relevant state practice. For these reasons, we would submit the dataset cannot constitute, for these proceedings, the record or the evidence in the sense of circumscribing the scope of the Chamber's factual analysis on relevant state practice and opinio juris. And while Mr. Newton offered his submissions in the name of the voice of objectivity or of empirical fact by using phrases such as the data shows or the record shows, we would suggest that his submissions should be treated with caution in regard to this claim of objectivity, since not only does it appear that the data may be incomplete, but he also offered at various times during his presentation his own subjective interpretation on these alleged objective facts, and that he was able to distill from the data the reasons why states did not arrest Mr. Bashir. Now, this only means that his submission should be understood and accepted as his interpretive analysis, and not as necessarily statements of objective fact. So where should state practice and opinio juris be found? Well, certainly Mr. Newton's data set remains relevant and helpful to this analysis. But so does other relevant data and evidence, including those we referenced, statements of states, national legislation, court decisions, and avoidance or cancellations of trips, which I believe Mr. Newton would also welcome. I don't think he would suggest anything otherwise. And all of these different sources, we believe, show wide divergence among states. And of course, this chamber also has the benefit of being able to consult the record in this case. In particular, the responses received from states communicated by the registrar to the pretrial chamber as to the steps taken by states parties to execute the warrant should Mr. Bashir arrive on their territory, which may also be relevant for ascertaining state practice and opinio juris. Now, on another fundamental point, Your Honours, I wanted to agree with Professor Kress that the appeals chamber should also set out its understanding of whether, the essential question, whether the national execution of a surrender request constitutes the assertion of foreign criminal jurisdiction, with all the attendant consequences of that assertion along the lines set out by Jordan. We agree with Professor Kress that an essential distinction should be made between the assertion of national and international criminal jurisdiction. If this distinction is not made out, then the ICJ statement in the arrest warrant judgment at para 61, discussed here at length, would be extinguished. That distinction would be extinguished. Indeed, we would say it is insufficient to say that this statement at paragraph 61 was made in passing, given how fundamental a role it plays within the judgment in identifying the outer scope of the procedural effect of personal immunities on the assertion and exercise of criminal jurisdiction. And as is also revealed in the separate opinions, this statement is clearly the product of considered deliberation. In other words, to say that the assertion of international criminal jurisdiction necessarily engages the procedural effects of customary rules of personal immunities so as to deny the exercise of that jurisdiction through preventing arrest and surrender, which is, again, the very heart of the arrest warrant judgment, would effectively shut down the alternative route identified by the ICJ at para 61. In Jordan's reading, as we understand it, and we invite him to clarify, this route would remain available should Mr. Bashir decide to either come visit the court or by conditioning the court's exercise of jurisdiction upon waiver by the state of the head of state's nationality. But insofar as this might be said to represent the meaning of Article 61 of paragraph 61 of the ICJ's judgment, we merely wanted to note that a domestic waiver is in fact a separate alternative route, the second circumstance identified by the ICJ, when it says in paragraph 61, quote, secondly, they will cease to enjoy immunity from foreign jurisdiction if the state which they represent or have represented decides to waive that immunity, end quote. So we understand paragraph 61 to be setting out separate, alternative, and not cumulative routes in terms of circumstances where the customary rules would not apply. And we invite the Chamber to draw out the consequences of the ICJ's statement at paragraph 61 to the extent it considers necessary. And finally, just very quickly, I wanted to take up your honours cue when you stated at one point, when trying to compare the ICC to the ad hoc tribunals, given the provenance of the referrals, I believe you stated, can't we say that the Security Council creates the ICC? And I think, from what I understood of that, I would merely suggest that, indeed, the Security Council creates the jurisdiction. And we believe this is key. Not the forum or institution, but the jurisdiction. At the ICTY, it was the former Yugoslavia, the territory of the former Yugoslavia from 1991 onwards. At the ICTR, it was Rwanda and Rwandan nationals abroad within 1994. And in the case of the ICC, the jurisdiction it created was in relation to Darfur, the territory of Darfur within Sudan, since July 2002. Simply put, if the Security Council did not refer the situation, the ICC would have no jurisdiction. So the Security Council creates the court's jurisdiction. And the creation or delegation of jurisdiction to the ICC, just like for the ICTY and ICTR, is made under Chapter 7 and is attached, as Ms. Brady emphasized on Tuesday and as has been recalled by Mr. Robinson, this was attached to an instrument that removed immunity. Thank you, Your Honors.
Good afternoon again, Your Honours. I'll take our last minutes to briefly address some of the submissions made on ground 3 of the appeal. Your Honours, this appeal brings front and centre the issue of what the court can and should do when it's confronted with an instance of serious non-compliance by a state party. The decision to refer the matter of Jordan's non-compliance is correct in law and in fact, and it is entirely justified and required in the circumstances. I will make 4 points. Firstly, what is Article 97 not meant for? Obligations owed to the court under the statute should not be taken lightly. And if a state party feels that it cannot meet its obligation, it must bring this to the attention of the court without delay. And it goes without saying, in a manner that allows the court to resolve the problem. Your Honours, time is of the essence in executing arrest warrants. That is a fact. The summit that Mr. al-Bashir was attending was just a day long. That is also a fact. Jordan knew that Mr. al-Bashir was the head of state from when it was first notified of the arrest warrant in 2009. That is also a fact. And arguments relating to head of state immunity in customary international law and treaties that Jordan invoked to resist its obligation are also not new. In these circumstances, waiting until the last moment to bring their inability to execute the warrant to the court's notice is quite puzzling. And when Jordan had itself invited Mr. al-Bashir to the summit, and had acknowledged his participation in that summit. What further confirmation was needed? When the magic words of Article 97 are uttered so late in the day and after working hours the day before the summit, what is the court expected to do? And what was Jordan's expectation that the court could do in such a short time? Most definitely, what the court could not do is to solve Jordan's alleged problem, the immunity issue, to Jordan's satisfaction before Mr. al-Bashir left Jordan. And so Mr. al-Bashir remained at large. Yes, Your Honours, one may dance the tango, but firstly, as it's already noted, someone has to lead. The court has to lead. And secondly, Jordan approached the court so late in the day that they did not allow the court the opportunity to resolve any issue, even assuming that there was such an issue. And even then, they only disagreed with the court's legal ruling and said that they would deny the request. And this is why, Your Honours, it cannot be said that there were Article 97 consultations in this case. Mere disagreements with the court's settled law should not fall within the scope of Article 97. If not, what then would prevent another state party from challenging perhaps your decision in this case, the appeals chamber's decision, in the very same manner that Jordan did? This is not just the law, it's common sense. When a state party fails to comply with its obligations and frustrates the court's function, an Article 87(7) referral equips the court with tools to address exactly such a non-compliance. But on the other hand, without the referral, on the other hand, without the referral, the court has simply no options. Secondly, why should Jordan's non-compliance be referred to the ASB and the Security Council? As Ms. Brady said, because Jordan knew what its obligations to the court were and it knew what the court's law was, that's decision paragraph 54, that despite knowing this, it decided unilaterally not to comply with these obligations, that's decision paragraph 53, and knowing fully well that seeking 97 consultations did not suspend its obligations, it still did so. And that's decision paragraphs 46 to 49 and 54. In paragraph 54 of the decision, the reference to the South Africa process is to 2 points. Firstly, the law that the South Africa decision expressed, which Jordan knew, not least through its participation in Security Council meetings 2 years prior to Mr. al-Bashir's visit. And I'd refer you, Your Honours, again to our list of authorities from yesterday, C3. Jordan had notice before the South Africa decision in 2017 was issued. And secondly, that Jordan may not benefit from triggering consultations in the manner that perhaps South Africa may have benefited from. And indeed it may not. Even if some doubt may have remained on what Article 97 entailed when South Africa triggered such consultations, there was no such doubt when Jordan approached the court. And that's decision paragraph 54. Now you may ask, is it unfair to refer Jordan when South Africa was not referred, especially when South Africa intended to withdraw from the statute? The pretrial chamber may exercise its discretion differently in different cases, depending on the facts, of course. And we think on these facts that the pretrial chamber was fair. What distinguished South Africa from Jordan fundamentally is that there were robust judicial proceedings nationally to establish South Africa's obligations to cooperate. Has this been so established for Jordan? We are not aware that it has. And I'd refer you to the South Africa decision paragraphs 136 and our response to Jordan's appeal, paragraphs 109 to 111 and 116 to 118. And Your Honours, we invite you to look closely at the decision and the record in the light of the parties' submissions. Thirdly, should there be any policy exceptions to executing the court's arrest warrants? In our view, none of the thoughtful proposals suggested by either Mr. Robinson or Mr. Newton, and again, I'm sorry that Mr. Newton is not here, should form a basis for your decision. What is clear to us is that these proposals cannot apply to the facts of this case. Jordan has never relied on such a policy in refusing to execute the arrest warrant, and the referral of non-compliance should be addressed on the facts of this case. Still, we now understand that Mr. Robinson's suggestion of accepting travel to high-level conferences is meant to apply to future cases, requiring the ASB to consider an amendment to the rules. With the greatest respect, the proposal seems to raise more questions than answers. And in this respect, we agree with Mr. Kress and Mr. Magliveras that we should indeed be very wary of any such notion. And we would resist this notion for these reasons. First, as we understand, attending intergovernmental conferences is a big part of the job description, so to say, of heads of state. So any exception could prevent, even frustrate, the execution of the arrest warrant for the entire term of the head of state, or at least for a big part of it. Second, this is the same issue, again, with the concept of essential contacts. It's entirely a subjective notion and could encourage an exception that would in fact become a rule and swallow up any possibility of arresting a head of state. And third, what if there are any disputes regarding the application of this policy? How should the court resolve this? And fourth, as we've stated in our submissions previously, the statute already contains a safety valve mechanism in Article 16. The UN Security Council has repeatedly declined to make such deferral in such a situation. And turning now to Mr. Newton's suggestion, the upshot of the proposal to us appears to deprive the court of its core ability to resolve legal disputes with states parties and defer the matter entirely to the Security Council, a political body. So we won't need to say any more at this stage. And fourth and finally, a state party's failure to execute the court's warrants cannot be seen in isolation. As your questions have correctly foreshadowed, such non-compliance must be situated within the larger context of the impunity that currently exists for Darfur. And this is something the prosecutor's reports to the Council have consistently underlined. As has been said, the Commission of Inquiry report that recommended referral to the ICC mentioned the involvement of senior Sudanese government officials. And so now, on Your Honours, we come a full circle from the first day. So in this sense, Jordan's failure to arrest Mr. al-Bashir has contributed to the existing impunity, and this is yet another reason to refer Jordan to the ASB and the Security Council. And none of the submissions that we heard this week have allayed our concerns. Thank you very much, Your Honours. This concludes the prosecution's submissions, and on behalf of all of us, that's Ms. Brady, Mr. Raston, Mr. Cross, Ms. Thiru, and myself, I thank you.
Thank you very much, Ms. Narayan. We will now finally give the floor to Jordan. 60 minutes.
I think I'd have learnt by the end of the week. Mr. President, members of the Appeals Chamber, Jordan's final submissions will be organised as follows. After some general comments on the nature of the current proceedings, I shall briefly recall our basic position as to how we think this appeal should be decided. I will then address a few points arising from positions taken by others with respect to the first and second grounds of Jordan's appeal. Professor Murphy will then highlight some important aspects relating to the third ground of appeal, upon which Jordan also places great significance. Ambassador Hammoud will then complete our final submissions. Mr. President, we've touched on many fascinating and fundamental questions of international law in the course of this week. But at the end of the day, in our submission, the issues that you have to decide in order to determine this appeal are relatively few in number, limited in scope, and we would say quite straightforward. We have set out our position fully in writing, in our appeals brief, our response to the professors of international law, and our response to the African Union and Arab League. And this week we have set out orally our position on each of the three grounds. And we have responded, I hope helpfully, to the many questions put to us. We maintain all of that in full, and I'm not going to try to repeat it. So the present closing submissions are an occasion to reaffirm just a few basic points and to respond to one or two outstanding matters. So I'll begin with a few words about the nature of the current proceedings. Mr. President, as we've said, this appeal does not seek an advisory opinion from the Chamber. Rather, it is an appeal against a specific decision by a pre-trial chamber which reached specific conclusions of fact and law directed against Jordan. Jordan sought leave to appeal certain aspects of the decision, and the pre-trial chamber granted leave to appeal based on three, and only three, grounds. It would, we believe, be in accordance with the case law to limit the appeal to the actual grounds of appeal. And we think that authority for this can be found, among others, in the prosecutor against Bemba decision, judgment on Mr. Mangenda's appeal against a decision in relation to compensation. I won't quote it, it's at paragraphs 22 to 23. The pre-trial chamber addressed certain issues, such as its finding that President al-Bashir has head of state immunity, which were not appealed by either Jordan or the prosecution. The pre-trial chamber did not address certain other issues, such as whether Jordan or Sudan violated an abuse of rights doctrine or violated Jus Cogens, or any number of other assertions that have been advanced in the amicus briefs over the course of this week. In our view, if the appeals chamber were to conclude that the pre-trial chamber reached the correct conclusions on fact and law with respect to any of the grounds of appeal, which of course we say it should not do, then it can reject the relevant ground of appeal and uphold the decision below. However, if the appeals chamber concludes that the pre-trial chamber did not reach the right conclusions, then the appeals chamber should uphold our grounds of appeal. And if, when upholding our grounds of appeal, the appeals chamber wishes to indicate correct statements of law, it is of course free to do so, and we accept that doing so may be helpful in guiding states and pre-trial chambers in the years ahead. Mr. President, Jordan's basic position on the substance of this appeal is as follows. The Rome Statute is a treaty, and when issues of interpretation arise, it should be interpreted in accordance with the rules contained in the Vienna Convention on the Law of Treaties. I might at this point just respond to what Mr. Cross said this morning, he rather skipped over the basic rule of treaty interpretation in Article 31 and led us to the supplementary rules in Article 32. And he particularly emphasized what delegates to the Rome Statute negotiations may have said about those negotiations. I would like to offer a word of warning. In my view, the recollections of negotiators are rarely a satisfactory basis for interpreting a treaty. The published documents of a conference are one thing, but the recollections of the participants have to be treated with great caution. Any participant, and this is natural, they have their own subjective views on what transpired. For example, they very often think they succeeded, and the treaty means what their instructions required it to mean. They're not really objective interpreters, so I just wanted to inject that word of caution. The central issue before the Appeals Chamber is how to address Jordan's cooperation with the court with respect to the arrest and surrender of a foreign head of state. The part of the Rome Statute that speaks to international cooperation with the court is Part 9 of the statute. And when you go there, you find a general obligation of a state party to cooperate with the court in Article 86, but only in accordance with the provisions of this statute. Article 98.1 then tells us that a state party shall, and I quote, in accordance with this part and the procedure under their national law, comply with requests for arrest and surrender. The obligation to arrest and surrender in compliance with a request from the court is predicated on that request being in accordance with Part 9. Article 98 then speaks directly to the issue at hand. It addresses the situation when a requested state is being asked to arrest and surrender a person in contravention of obligations under international law with respect to third states. We regard the text of Article 98 as clear. Its ordinary meaning